to be part of the Open Language Summit that took place in October. Remember, I was telling you about all these different people that we had coming to talk to the representatives of the National Foreign Language Resource Centers to tell them about this new thing called open education. And they were very interested in meeting Georgia because she is a lawyer, and she also has a very deep background in copyright and in library science and all the issues that are really important to people in our field, foreign language education. But here's the blurb that it has, her bio, that I got right off her website, so it should be up to date. Georgia Harper is the Scholarly Communications Advisor for the University of Texas at Austin Libraries, where she focuses on issues of digital access. She was Senior Attorney and Manager of the Intellectual Property Section of the Office of General Counsel for the University of Texas System until August 2006. Currently, she represents the Office of General Counsel as outside counsel for copyright. She is the author of the well-respected and often cited online publication, The Copyright Crash Course, that provides guidance to university faculty, students, and staff concerning a wide range of copyright issues. And importantly, it is open. It is freely accessible to all universities and colleges. Anybody who has internet access can take a look at the Copyright Crash Course. And of course, this talk today will be on our website, on our Open Language Summit website. So thank you all. Thank Georgia for coming today. Please, a round of applause. Take it away. And I do want to say one other thing. She asked that this be interactive, so as questions arise, please ask them. That's the moment.
Thanks. Thanks again, Carl, for inviting me, and thank all of you for coming. I wanted to start by just noting that the kinds of materials that you make in creating these open language resources are not really very likely to harm copyright owners' interests, and they're also quite valuable to the public in the way that copyright law defines value, and that is increasing knowledge. So when you have materials that are both high value in terms of copyright's values and of little risk of harm to copyright owners, you usually don't need to worry too much about copyright. But these days, that's not really the case, because copyright law has gotten a little bit out of sync with the way we do things today. We're in a period of transition from having a copyright law that was built for an analog world and having the digital copyright law that we really need. So we have to sort of acknowledge that what worked 25 years ago, certainly 50 years ago, just doesn't really work very well today. And in fact, it probably won't for some time. So what that means is that we have to deal with perceived risk of harm, even if it's not real. And that's what we're going to talk about today, is how to manage the risk of copyright infringement in creating these open educational resources. There's really 4 choices for managing copyright infringement risk. When you're creating something new for the public, whether you're creating it to be open or actually whether it even goes behind a password-protected website, they're the same. You can either make it yourself, you can license it from someone else as either the starting point for your own creation or just to include in your creation. You can rely on the Copyright Act's fair use provision, or you can rely on Creative Commons licenses. We'll talk about each one of these in turn. Making it yourself is risk-free, and it may be low cost or not. It takes time and money. Well, time is money. The costs are not always what they seem on the surface when you start out making things yourself. Making good materials from scratch requires that you have good, talented people and that you give them the time and the resources to do a good job for you. There's also a big minefield in making it yourself. securing copyright ownership in the person or the entity that you want to be the owner of the new works. Ownership under copyright law is pretty straightforward up to a point. Then it becomes very technical, and that's where the minefield is. It's simple if you're just one person creating something yourself. You're the owner. You are the creator of the work, the author, and the owner. But jointly created works can get tricky, and if you want the owner of the work to be this entity or some other person besides the person who's actually creating it, that's where you have to really play by the technical rules of the Copyright Act, or you won't get the result that you want. You've either got to arrange for the work to be work for hire, which means it's created by an employee working within the scope of his or her employment, or a contractor working under a written agreement that says it's work for hire, or you've got to get an assignment. And when you work with the contract kind of situation, it's probably best to do both, have a contract and an assignment. Otherwise, the creators become contributors who own their own contributions to your collective work, and that's probably not the result that you want. It really messes you up when you're trying to deal with someone as though you own the work and you really don't. So for example, if you wanted to license the work to someone, they would want you to be warranting that you own it.
Could I ask a question?
Yes, absolutely.
So the idea of contract or assignment, in the context of the University of Texas or a university, it's not only like a technical person you're hiring for, like a work for hire, a specific job, but also the content creator, the faculty members. So I can imagine a course having many, many, many different people.
Right, that's
and
exactly.
I'm not sure that do they fall all under contract or work for hire and assignment, or are those the only two categories?
Well, most of us who, assuming we all work for the university, most of us are employees working within the scope of our employment when we create materials, especially the technical people. But there's a special exception for faculty members here at the university that allows faculty members to own their educational and course materials, as well as their scholarly works, like their journal articles, their textbooks. So that creates some ambiguity about whether a content creator would own his or her own, well, own their part of your work, unless you specify to them that you want them to acknowledge that this is going to be work for hire. You know, under the Regents' rules, you would be permitted to say you own this by yourself. But because it's supposed to be part of this project, let's say, we need for you to acknowledge that you recognize it's owned by, well, the entity, I assume, some entity, either the center or the university or something other than the faculty contributor. So it can't, that's what I meant when I talked about there being a minefield, and you can run into all kinds of very technical and complicated things.
So I guess a general rule of thumb would be for your content providers, the faculty members, to make that explicit that this is a special kind of a project that is open and that you are contributing to the greater good and so forth, and then you no longer own the notion of authorship or royalties or any of those things that typically goes with this.
Exactly. There are actually two ways to go about it. And when you mention to a faculty member that they no longer own something, they usually, you know, go like this: wait a minute, I'm not sure I want to do that. Because they might have other uses for these materials. They may be working on a textbook. They certainly want to continue to use them in their own classes. So when you appear to be stripping them of ownership, you're really you're asking for more than you really need. Because what you really need to manage your workflow and to deal with the materials the way you need to is you need a clear set of rights to do what you want to do. So a better way to look at what you need from faculty members is a set of rights to do what you need to do, and leave them with ownership, which gives them the right to do everything else. Now, I can certainly tell you a lot more about that in detail if you'd like. It doesn't need to be any longer than a page. It's not a real, it's not like a big contract that everybody signs. It's more like just a permission, basically. It gives you the permission to do what you anticipate you'll need to do. But it's a very good point. Any other questions about? So now we're going to move to licensing. This takes time also, and it can be very expensive. Many copyright owners don't have pricing structures that are really tailored for nonprofit educational users. Their prices tend to reflect the assumption that their licensees are for-profit companies and that they're going to build into their purchase price for their product enough of a cushion to cover their expenses in creating the materials. For nonprofits and educators, we don't have that. For us, those costs are simply sunk, and all they do is raise the price of creating the materials for us. But licensing and permissions can also be time-consuming and even unsuccessful. Identifying copyright owners, contacting them, getting a response, it can take a long time and ultimately be very frustrating. Often there's simply no response at all. Sometimes you can't even figure out whom to ask. But if you have sufficient budget and the lead time to get permissions to use what you want to do, you can significantly whittle away your risk of copyright infringement. Explicit permission, well documented, is excellent insurance against infringement claims later on. Sometimes, to our great relief, copyright owners will state explicitly on their sites exactly what the public is entitled to do with their works. They may give you the rights to do exactly what you want to do. So it's good to find any site that you use for resources, find their terms of use, and determine whether you already have, they've already given you the right to do exactly what you want to do. Now, Creative Commons licenses are but one example, a very good example, of this kind of explicit statement, and we're going to talk about those later. But any kind of explicit statement is a good thing. It can save you a lot of time and money. But in other cases, the owner of a copyright, of a website won't say a word about what they expect the public to do or what the public's entitled to do. There is, nevertheless, an implied license to use the materials that you find on public websites in certain ways, the ways that a normal, reasonable person who posted things online would expect that the public would use them. Now, arguably, many nonprofit and educational uses are going to fall right into that that implied license. But that's the problem with it. It's vague. You don't necessarily know what's in there, and it's arguable about whether any particular use actually fits or whether it was reasonable to imply it. Now, it's probably very reasonable to imply that the owner of a university website or of materials on the website or of other nonprofit educational websites expect that the public will make nonprofit educational uses of their works. That's what they're up there for. But to imply that same license on the part of the owner of a commercial website would probably be a lot more risky. So now we'll turn to fair use. Relying on fair use is going to save you a lot of time and money. But just as those implied licenses do, fair use increases your risk somewhat because you can't be absolutely sure that what you think is fair is really fair. And if a copyright owner objects to your use after you've already incorporated materials, you may have to modify your materials after you're finished to address someone's concerns about copyright. Actually, that's an important point. It's really good to have a responsive takedown policy and procedure if you're going to put materials out for the public, because that's one of the most important ways to ameliorate people's concerns, set them to rest quickly and in a way that meets their needs. There are strategies that you can do to reduce your risk of infringement when you're relying on fair use. Now, these could, of course, be the subject of an entire day's conference, and they have been on many occasions. I'm only going to mention a few of them here. The first is to limit your reliance to small parts of others' works. Even in commercial contexts, small parts that are used in ways that transform the underlying work, and I'll talk more about transformative uses in a minute, can be fair. If you need to use more than just a small amount, the second strategy is to limit your reliance on fair use to those cases I talked about a minute ago in licensing, where you either can't figure out who to ask, or you've sent off a permission request and you get no answer, or you can't, for whatever reason, it's not working out to license the work. When you have difficulty finding an owner, it's actually very unlikely that they even exist. But if they do exist, it's unlikely that they're going to be noticing what's online and seeing what you're doing. And even if they do notice, it's unlikely that they'll be displeased by what you've done. But even if they are displeased, it's unlikely that they're going to be dissatisfied with anything more than just a takedown, which is, again, why I mentioned the importance of having the takedown policy. These kinds of strategies of small parts and being sensitive to whether someone's in the commercial market or not, and transformative uses, which I'll talk about, these reflect reliance on community standards to define the scope of fair use. The Center for Social Media at American University has been working for years now to help communities of users document their own best practices. These statements help community members feel more confident about relying on fair use. This is the statement that the community of open courseware creators developed. This one is, of course, going to be very useful to anyone creating open language materials because it's right on point. It's been out for about at least a year now. The open courseware best practices indicate that there are two common questions that have emerged from the case law that are core guiding principles for fair use reasoning in situations like those you'll encounter in putting materials out for an open audience, where you're using things that were originally created for some other purpose in small amounts. The first question is, of course, is the use transformative? That is, are you adding value to these materials? Are you repurposing them for something new, for a new audience? And the second one is whether the amount that you're using is appropriate for the use that you plan to make. Basically, are you not using any more than you really need to in order to make your point? These two common questions about transformative use and amounts form the basis for these best practices statements as they would apply to 5 varieties of uses that are typical of, again, open courseware. Incidental uses, critical, analytical uses, illustration, demonstration and explanation, and supplemental and assigned readings. Now, I'm really recommending that you have a look at this. It's so on point for what you're doing, but it'll help you not only to understand what's fair use, but why.
Could I ask a question
Yes.
again? So to give a concrete example that language teachers use all the time, songs,
Yes,
and songs, of course, are copyrighted,
of course.
but in fair use for educational practice, we want to use a song for all kinds of reasons.
Right.
And when you mentioned earlier, just a minute ago, that you should limit it to small parts,
Right.
we typically want the entire song. It's
Right.
not just one or two lyrics. We want the whole thing from beginning to end.
Right.
So are you suggesting then we could go ahead and do that, but still explicitly have some kind of takedown policy so that if by chance they were to contact us, we would then, of course, take it down?
Are the songs the super popular songs of today, or are they more esoteric? Do you get?
It's a mix. It's a mix, yeah.
Because that matters a lot. If you're dealing with things that are commercially available right now at a reasonable price, which we'll talk, again, that's another important element of the analysis, you're not on quite as good a ground as you are with things that are not so easily available. But in the end, if you're not sure, a lot of things are going to be crystal clear on one end or the other of a continuum, but there's always a lot in the middle, the gray. And if you're in there and you're not sure, certainly you can put things out there that you think, I'm not real confident, but let's just see what happens. And many, many times, nothing will happen. There is always a risk that someone will get upset, but again, these days, a notice of some sort that comes to you that says, we're unhappy with what you've done here, and a very quick and very courteous response is usually all that's needed to take care of the matter. But I will say that people's risk tolerance varies dramatically. And whereas I might be comfortable doing that, and you might too, there might be someone else in your organization even who just freaks out at the thought. So, you have to talk about your risk tolerance levels, because that goes into this decision. There is no right answer here, in other words. We all, within that gray area, will have slightly different ideas about what we're comfortable with. There's a question at the back, and then I'll get yours. Yes?
Is it safe to assume that anything we put behind UTE-ID restrictions can fit in the fair use world?
Not anything and everything, but more does, yes. More fits into fair use when we've put it behind a barrier than fits into fair use when we put it out there. The small parts, for example, is still valid even behind the password protection, but the small parts can be larger. Also, I don't mean to give you the impression that only small parts are fair use, not at all. Entire works can be fair use too. It depends on whether it's the amount that's appropriate for your use, and some sensitivity, again, to being transformative. In other words, don't just put it up there for, this is a really cool song. It needs to be clearly related to your educational purpose, and you're looking at it for something other than just, isn't this a cool song? And that you're sensitive to the market. If the work is just easily available right now on iTunes for 99 cents, that's not as cool. Any other? Oh, wait, there's two more. Yes. Wait, you first and then you. Yes.
What about stuff that's free on YouTube?
YouTube is a wonderful resource, and I'll talk about it a little more in a moment. But the thing with YouTube is that you can use anything you want there, but they have terms of use, and they're not as generous as we would like. They don't permit you to take things out of YouTube and, bring them into your own work.
So if I put a YouTube link in a teaching PowerPoint, Am I taking this out or am I
No. Taking it out would be if you,
download
I'm
it?
not even sure how you do this, but it can be done,
download
obviously.
it. Okay.
Yeah, you pull it out of their presentation format and you isolate it on your own website. That they don't like. And that's a contract violation. So
Well, as long as I keep the link,
links
my
are
students
fine.
click on the link.
Absolutely.
That's good.
Yeah.
And I'm sorry.
Oh, go ahead.
In terms of, you said older versus newer songs. So I'm thinking, from what I understand, we better off choosing like Edith Piaf rather than somebody who's alive and singing today, yes?
Probably. Edith Piaf is, of course, also available, but it's so hard. I mean, it's hard. That's why the let's try it and see what happens thing might be a good choice. You almost also might consider whether you really do need the whole song. But again, you know, it's like a continuum. Think of it always as a slide. You know, the less you use, the more solid you are in your footing.
But there's also, as you said, there's a continuum of access. So it's not just you're taking something and then putting it online for the whole world. You're talking about this primarily fair use behind a protection. So students who are protected through our university, EID.
Now but that's different. I mean, when you talk about open language, I'm talking about the whole world.
Oh, you are, okay.
I am talking about the whole world, yeah. And I'm talking about fair use in that context of using things that the whole world will get to see. That's why the less than the whole song becomes more comforting, let's put it that way, if you're putting it out there for the whole world.
Because as a policy at the Center for Open Educational Resources and Language Learning, we've decided that if we haven't made it and if we haven't gotten some kind of permission from the songwriter or the filmmaker, that we will put it behind closed doors. We put it behind, university protection.
That is certainly an option.
So
But
otherwise, it's open when we
Right.
have explicit permission.
You could add to your repertoire there of your responses, what you do. We could put some of it out there. See what I mean? Just a moment. Yes, I wanted to get to your question. I'll come to you next.
I work with ancient languages, Greek, and fortunately, in the case of Greek, as you probably know from the library, we are in this amazing situation of having the entire corpus of Greek literature online. This is the Thesaurus Linguae Graeca. And the university does have the permission for use of the TLG. Recently, the TLG has been putting out a warning every time you go through the business of going through the license, the UTID. They tell you you can look at this stuff, but you cannot download any of it. Now that seems amazingly restrictive.
It sounds horrible.
Yeah.
My guess is, knowing how things work at the university and in the library in particular, is that if we have permission to use something, the only reason we would put up something like that is because the license requires us to do it. We would, and first of all, we try our hardest to never license anything that we know can't be used in the way our users expect to use it. And that's not how they expect to use it. So I feel confident in saying that it's highly likely that the university had no choice. If they wanted these materials, those were the terms on which they could have them. That said, we also include in all of our contracts a clause that says, we can't make people do what they're supposed to do. We as the university do not have the capacity to police every user on this campus to be sure they don't do anything wrong. So we won't allow the licensor to make us responsible for problems. If the licensor is aware of a problem and brings it to our attention, we can do something, but we're not out there looking to see what people do.
Right. Well, the TLC, from time to time, sends warnings to the chairman of the classics department.
I'm not surprised if they feel
saying,
that way. Yeah.
We have noticed excessive downloading.
Yeah. some people just don't really, well, okay, this is my own personal opinion now, that it takes copyright owners some time to sort of get comfortable with the way people use their works, and they're clearly not very comfortable with people using their works. Or their business model depends on a revenue stream that isn't very practical. They have some problems. There's one other licensor, Harvard Business, HBR, I never can remember what it stands for, Harvard Business Publishing. And they are the same way. They just can't quite accept that, if you put it out there and we pay for it, people should just be able to use it.
Of course, TLG, they're under pressure by publishers. Because, of course, to create the TLG,
Yeah,
they had to negotiate with publishers all over the world
right.
to use these editions and to put them online.
So basically everybody's being told you've got to do this, and it's just being passed down the line. So it's really up to the ultimate consumer to decide, how they're going to deal with that. We got it under whatever conditions we could. And you had a question?
Yeah, I'm a documentary filmmaker, and one of my main resources is www.archive.org. It's fantastic in the Prelinger archives. And for example, they'll have, the old Max Fletcher cartoons like Betty Boop and Popeye will be long past their copyright, has run out. But the thing is, though, even though that cartoon might be, won't have any copyright protection, it'll say public domain, it might have like a Cab Calloway song in it or something like that. And when I look up that song specifically, it'll still say that it applies. So, I don't know if if kind of those layers of copyright protection is common, if it's better that I just use the video primarily, or if that's one of those try it out and see what happens.
Right. There are layers. And usually, though, if the container work is out of copyright, it can't have contained anything that's newer than it. And that's in the real world of this kind of stuff. In the web world, however, you can run into situations where something that is in the public domain somehow is associated with things that aren't. Sometimes you won't even know this. Sometimes it's not clear that there are separate copyrights involved. But when it's clear, you try your best to pay attention to it. When it becomes almost impossible to extricate things and use them separately, the let's see what happens approach is certainly not outrageous as an option. But you can also look at what it would cost to get permission. Again, these are strategies. What I'm trying to give you is a palette of strategies to try, depending on your risk tolerance, depending on how much money and lead time you have. And in fact, I think this particular best practices guide, the one for documentary filmmaking, might be of real interest to you because this is the other side, the other end of another continuum of open uses. On the one side, we have the open courseware that's nonprofit educational, but things are out there for everyone to see. And then over here, we have the same thing out there for everyone to see, but these are commercial undertakings where they will be making money. And yet they have exactly the same questions, exactly the same guiding principles. Is the use transformative? Have we used the amount that's appropriate? And they have the same kinds of uses, illustration, critical analysis, that kind of thing. So to read two of them, not just one, but on both sides of this continuum, gives you a really good sense of what the factors are that go into managing risk, how to moderate your risk. You'll get, if you were to read none other but these two, you'd have a really good sense of not what to do, but what kind of risk you're undertaking when you do what you need to do. And again, your own personal risk tolerance, you have to be aware of the fact that it's part of what makes you decide what you want to do. It's not the law says this. Yes?
Sometimes copyright holders, especially outside the United States, where country X or Y, whatever, may not have a fair use doctrine. Put absolutely amazingly restrictive statements on
Right.
books or on sheet music, for example. Sheet music, polizeilich verboten,
yeah,
completely to make any copies. Now, there's no way you can have an ensemble, a
Right,
string quartet,
without
or something,
copies.
without making a copy because you have to mark it.
No,
because-
no problem. Thankfully, the law that applies to our uses in this country is our law, and we have fair use. It also applies when what you're using or how you're using it is electronic. As long as the server's here, the law of the US applies to our uses, even though we're serving it out to the whole world. So when you do something for the whole world, though, I'm not talking about making a copy for use in an ensemble, in the inmates' recital hall, but rather we're wanting to put something out there on the web for everyone, open resources. And you've used something that someone says verboten. You can recognize that, number one, they're in this commercial sphere, even if they're saying no, they're not hard to find. They're not, they're there. So they may notice what you're doing. And again, if you rely on the small parts, you'll be a lot less likely to draw a complaint than if you were to put something in its entirety out. Also, the transformative nature of your use out there will help you to strengthen your fair use case. Still, even if you've done everything right, when you get a takedown notice from someone like that who you know is not friendly about this, you may still want to just take it down, even though you did your best. Yes?
I'm sorry, about movies, there's a bunch of extracts on YouTube, so I understand if I just use the link,
Right.
click on the link, it's fine. What about if I do the same with other websites, like there's a bunch of French Allo Cinema, stuff like that, that have their own extracts. If I just put the link in
Yes.
there, that's okay?
Linking is always okay. There's just nothing wrong with linking. Of course, the downside to linking is that someday it may disappear, but that's a management issue, and we all have to deal with that all the time, so it's not the end of the world. So I'm going to review here risk tolerance, because that's what we've been talking about quite a bit. As I indicated a moment ago, risk is related to the availability of a market for permission, especially when you need to use more than a small amount and your use is not very transformative. Now, hopefully, in this context of open language, most of our uses are transformative. But for those times when we're a little concerned, we need to use the whole thing, you're on strongest ground here when you're using materials that aren't easy to license. If it's super simple to get permission, that's not your best case for fair use. On the other hand, when the owner is difficult to find or doesn't respond, your risk goes way down. So keep that key point in mind. The other major point is how transformation of the underlying work reduces your risk. These types of uses are really at the heart of what fair use is all about. It's protection of our First Amendment rights to criticize, to comment, to take issue with someone, as well as to point out or just discuss their work. Courts are really generous in their support of transformative uses, even if the copyright owner makes a license available. This is one of the cases where whether or not whether the person is in the market trying to make money off their work, it almost doesn't matter if your use is highly transformative. Now, this is the kind of use, these highly transformative uses, that the documentary filmmakers' best practices deal with exclusively. So there again, that's why I recommend reading it. It gives you a really good example of how to be transformative in your use.
You say highly transformative, and just analyzing a set of interactions, dialogues for a language class, is that considered highly transformative?
Well, I can't tell you exactly, but again, if you look at the documentary filmmakers' cases, you'll get good examples of what they consider to be highly transformative. That will be easier for you to apply than for me to. There is a lot of material online about copyright and fair use. The website that you referred to that I that I created is the Copyright Crash Course, and it has links to a lot of other sites as well. So if you want to know more about fair use, certainly you can find it. The best practices, though, at this point in time, we didn't have them just a few years ago, and I have to say that they have made helping people understand fair use much, much easier. So I highly recommend that you refer to those.
And what's the URL for this copyright crash course?
You can just Google it. It'll come right up.
With that name?
Yeah, it'll come right up. Now, if you don't have a lot of time, and you don't have a lot of money, and you don't want much, if any, risk, this strategy is the one for you. You need to rely on materials whose owners have already stated exactly what they're comfortable with you doing. The only thing you need time for here is to learn good CC search strategies. There will, of course, be times when no one has posted something with a CC license that meets your needs. And in those circumstances, you can fall back on your other strategies, fair use, licensing, making it yourself. But I'd strongly advise that you learn to do good CC searches so that if you do conclude that there's nothing out there, that you're actually correct. For images, my favorite search strategy is to just go directly to Flickr. Under the Explore menu at the top of their page, there's an entry for Creative Commons. You click on that, and it pulls up the Explore Creative Commons page. Now, you'll see, I didn't clip the whole page here, but you can see that there's a progression of licenses that goes on down the page. They start with the least restrictive at the top, and they get a little more restrictive as you go down. Keep in mind, though, that there isn't a one of these licenses. There are only 5. There isn't a one of them that will be too restrictive for what you need to do. It's just that some owners want you to be, they don't want you to make any changes. Other owners only want nonprofit uses, but again, that doesn't matter for us. Some of them will let you make changes, but if you do, they want you to put the same license on your work that they gave you to begin with. Some people, don't care about any of that, and they just want attribution. That was the CC BY, CC *BY license that I have on my work. That's where I always start when I'm looking for images, the attribution license, because I figure it's less work for me to keep track of what I can do when I can do anything. CC licensed audio and video can be found on YouTube and other sites like that, but you can also search for them on the CC site itself. You can also install a CC search engine filter on your Firefox browser if you use Firefox. All of these options allow you to search the web for materials that have the CC license actually embedded in the code of the page that presents the materials. That's how you're able to search for them.
On Firefox only?
That's the only one I know of. that has that. But I haven't really found that, I mean, all I have is a tab on my Chrome browser for the CC search site. It makes it, pretty
So
easy.
I can understand that. With Firefox, you can put some restrictions into the program.
Yeah,
so that
they,
it will only take you to things that are
Yes.
copyrighted, or
no, only to things that are licensed for reuse, where you don't have any question about the fact that you can use this.
For open materials, right?
So, CC licensed images and text can also be found from this CC search page, or you can go directly to the sites. Like I said, I go to Flickr. I like to search from the CC search page when I want to find a variety of types of content on the same subject. That way I don't have to switch from like Flickr to YouTube to Google. And I can use the same search for a lot of different types of content. Of course, you can go directly to your favorite search engine. Mine is Google. Google allows you to access CC licenses in its advanced search feature. So you select advanced, let's say image search, advanced image search. And the way you select that is you just Google it, advanced image search, and up comes advanced image search. There used to be a button right on the search box for advanced search, but it's not there anymore. Things change. So you select advanced image search, and then there'll be a page full of things that you can do to fine-tune your search. At the very bottom are the usage rights. You select the particular license that you want. Like I want ones that are for reuse. And then down at the bottom, there's little check boxes that you can't see, but you can say, I want to be able to do everything with it, or not. And you're good to go once you've got your license selected. From then on, anything you search for in the Google image database will be licensed for reuse. Now, this is just a one-time thing. The next time I open my browser, it's gone. I do it again. Yes?
Do they have advanced search? Do they have other type than images?
Yes, they have. Their video can be advanced searched. I'm trying to think. I know that I'm not sure about what all advanced search applies to, but you can try it out. Just say advanced video search, advanced text search. So speaking of page code, remember I mentioned a minute ago that there's a little snippet of code. If you're putting materials out there for a public audience, and I know you already do this, but if you're putting stuff out there, you can do that audience a huge favor by letting them know exactly what you want them to be able to do without asking for your permission. And that is, of course, by affixing your own CC license to your materials once you get them out there. It's really easy. The CC website makes it very simple for you to, well, they explain what each license is. They show you how to select the one that's right for you. They give you a little form. You just click here, and they generate the little snippet of code that you copy and paste into your website, into your web page, so that your works are not only evidencing your choice so the public can see it, but that's the code that makes people able to find your works when they want only CC licensed things. So in effect, you're doing for someone else what others have done for you by making your posted works clearly available for use and reuse. So there's no risk to those users if they're doing what you've given them permission for. No matter which route or routes you take, you've got to create some sort of spreadsheet that allows you to document how your works were authorized. So you'd write down your licenses, your purchases. You'd indicate when you relied on fair use, why. you would, if you made things yourself, you would indicate that they were either work for hire or that you got an assignment. So it's good to have a primary strategy with fallback to the others as needed, depending on whether you have more money or more time or more risk tolerance. But how you decide is what I've given you a little bit of to think about, and how to decide and to figure out what you'll do when you start working on materials to manage your risk of infringement. Normally I'd ask for questions, but we are right at 3 o'clock, so unless there's a burning question, I'll close. Thank you.
Thank you.